I'm Jeff Rosen. I'm a law professor at George Washington University and a co-editor with Benjamin Wittes of Constitution 3.0, Freedom and Technological Change. I am very skeptical of generational claims when it comes to the privacy debate. It's true, younger people have different norms of exposure than older people in some regards. They're more willing to go through naked body scanners at airports because they look much better than the rest of us. They are more willing to share details of their personal lives on Facebook. But these same young people are quite savvy about editing their Facebook profiles the moment they graduate from college or law school and are applying for jobs, and are so savvy that they may remove a lot of the embarrassing drunken Facebook pictures, but leave up one or two because they've learned that if their profiles look too clean, the employers will think that they're trying to hide something. So as all of us grow up in this digital world, we all adjust to its exigencies, and it's not the case, I think, that this great new kumbaya universe, everything is going to be shared and we'll just get over our hang-ups about seeing each other's secrets, and light and sweetness will prevail. It's not descriptively right, and it's also would be a undesirable world to live in. Nevertheless, will norms change in light of new patterns of behavior? Of course, of course. People are not going to draw the line in the same place. Certain forms of exposure that used to be frowned on will be embraced. Much of that is to the good. Many people have complained about the paternalistic aspects of privacy, efforts to keep women in their place by enforcing norms of modesty. I mean, there's no point in being a Luddite or a moralist in acknowledging that the degree to which technology is changing norms of privacy. The one thing I want to resist is the claim that there will not always be some line that is important to draw and defend. And there will always be some invasions that are unreasonable. If we're to be secure in our persons, houses, papers, and effects, as the framers insisted, then there are certain forms of observation and surveillance that will have to be considered unacceptable. And that's why it's so important that courts, legislatures, and citizens negotiate those lines and insist on them, and not lazily insist, oh, no one will care, you should just get over it, and so forth. Reasonableness requires judgments, and those are the kind of lines that we have to draw. Yes, that's a very good way of putting it. The Constitution asks questions rather than providing answers, and it identifies constitutional values that change over time and may not always rise to the level of being constitutional rights. It was so striking throughout the book that in many cases there was some value that was being threatened, even though there was no obvious right that was being threatened. That the problem of forgetting on the internet is one of them. It's very difficult not to be able to escape your past, to lose a job because of the ill-advised drunken Facebook picture that you posted. That doesn't mean that you have a right to have it removed, and it doesn't mean that if a right is created, as Europe is trying to do, that won't have bad consequences on other constitutional values like free speech. So that's why it's such a complex and fascinating area. But what's so inspiring about our beautiful Constitution is that it provides a framework for discussion that challenges us to preserve values in the face of change, as they always have changed. The technology has always challenged our constitutional values. We've responded in more and less effective ways, but at least there's a framework for the conversation that we can root in the text and history of this wonderful document. It's a hard and important question. Is technology transforming our constitutional debates in degree or in kind? Are these entirely new challenges, or are they just different versions of the old questions? You can argue it either way. I remember once making the argument that the challenges were new, and Kathleen Sullivan, then the dean of Stanford Law School, said, no, this is just the Winnebago problem. And what she meant by that is everyone who takes criminal procedure in law school knows all of those line drawing cases trying to figure out when a passenger compartment becomes a trunk. And the challenge is the Winnebago, which looks like a combination of a trunk and a passenger compartment. And for Kathleen Sullivan, there were always technological challenges to privacy. Brandis worried about the Kodak camera and the tabloid press. And now we have Facebook, so many more people are affected. than the aristocrats in Brandeis's day who worried about their social privacy being invaded. Now it's 800 million Facebook users rather than 3 Boston aristocrats, but it's just a difference in degree rather than kind. I respect that position, but my instinct is something has changed in kind, and that is the fact that the private corporations now have so much more power over these values like privacy and free speech than they did 100 years ago. It's true that there was the Kodak company, but it had so much less ability to affect our entire national debate than Facebook did, that it strikes me that the challenge of translating constitutional values into a world where they may not even apply to private actors is a distinctly new problem that's become more acute. But there's no point in fussing too much about this. I'm perfectly willing to acknowledge that maybe it's a different in degree. Maybe it's a difference in degree, but if that's the case, it's a really, really big difference in degree. I'm so glad you asked about my hero, Justice Brandeis, and I can't resist this opportunity to plug him by, here, I've got him sitting right here on my windowsill, so I'm going to bring him over and have him gaze soulfully into the camera. You see his Lincoln-like profile, which was so admired, and I'm going to have him looking soulfully out the window because he was so, Mr. Justice, I'm being very respectful in holding you near me here, but this great man, more than any other justice of the 20th century, insisted on the task that we've been talking about today, which is constitutional translation. He never would have accepted arid formalisms which said that if the framers defined privacy by the law of trespass, then only the law of trespass should govern. In the Olmsted case, where the court refused to regulate wiretapping because there was no physical trespass of a suspected bootlegger, he looked forward to the age of cyberspace and accurately said ways may someday be developed by which it's possible to extract secret papers from desk drawers and introduce them in court. He anticipated Skype, or the kind of technology that we're using in this office today. He said at the time of the framing, a far smaller invasion was held to violate privacy, the search of private desk drawers to read diaries. We need to translate the Constitution to guarantee as much protection in the 21st century as the framers took for granted in the 18th. I'm heartened and encouraged that a majority of the Supreme Court accepted Brandeis's challenge, and that Justice Alito cited Brandeis's dissent in Olmsted in insisting on the necessity of constitutional translation. But I believe that Brandeis's example showed that we cannot rely on judges alone. Why was it that in 1890 there was no national constituency for trust busting, but by 1913, the election in which Brandeis was advising Woodrow Wilson, 2 of the major presidential candidates, Wilson and Roosevelt, were both declared in opposition to the money trust, to the curse of bigness, and determined to pass antitrust legislation to rein in the banks. It was because of political activism. It was because the progressives started as an elite movement and insisted on the importance of expert opinions, but also mobilized citizens to lobby state legislatures who passed laws like the minimum wage laws and prototypes of antitrust laws, and created a bipartisan national constituency around trust busting. I look at the political debate today, and I'm encouraged, frankly, by the similarities, not the dissonance, but the consonance between the Tea Party and the Occupy movements, not in all respects, obviously, but in their opposition to the banks and their fear of concentrated corporate power. They suggest that there might be a mobilized constituency for curbing unlimited corporate power. Whether they will end up convincing the major political parties to pass regulations that rivaled that of Roosevelt and Wilson, or whether they fade away, as so many other fringe movements have, depends on whether they can persuade the mainstream presidential candidates, Romney and Obama, that they really have the numbers to make a difference. But I think, using them as a model, that Brandeis would have insisted that these issues involving technology in the Constitution are not ones that should be limited to judges or administrators or experts, or certainly not, God help us, law professors. They're issues that all citizens have a stake in and a duty to engage the ability to defend constitutional values is our most precious heritage as Americans, and we have to seize it. And that's why I always love inspiring myself with Brandis's wonderful words. He said, if we would guide by the light of reason, we must let our minds be bold. Thank you.